And welcome back to the National Lawyer Show with well-known personal injury attorney Michael Friedman. Michael, let's talk automobile insurance issues. A friend of mine told me that he got into an automobile accident and recovered nothing at trial, even though the person who hit him was mostly at fault. My friend was just somewhat at fault. That doesn't seem fair, does it?
Well, it's interesting. In the United States of America, there are two standards of negligence that we as attorneys must provide in order to recover. They are comparative negligence and there is contributory negligence. Comparative negligence is what it sounds like. It's kind of easy. A jury can give a verdict where they compare the two negligence, and they can decide that party A is 80% responsible for the accident and party B is 20% responsible. So party B, as the moving plaintiff, can recover, but only 80% of what the verdict is. Fewer states in this country, right now I believe it's 7, have what we call contributory negligence. And under that standard of negligence, if a jury comes back and finds that one party to be 20% responsible, they get nothing. They get 0. In fact, if the jury finds that they are 1% responsible for the accident, they get nothing. Many questions about which is fairer and which is easier. Which would we as attorneys prefer? Because as we go into different states trying cases, the standard changes. So what we might be able to do in one state to win our case, we can't do in another state. Where we are comfortable with, well, we know that the other defendant is way more negligent than my guy, so I'm really not worried. One state, that's okay. In a contributory negligence state, that's not okay. So a completely different way of handling your case and trying the case between those two.
Which one do you think is fairer?
It's a very difficult question because as you practice in your individual state, you get used to that standard of negligence. And everything is based around it. In other words, you can actually settle a case a little bit easier after a while if you're used to contributory negligence. Because both sides recognize that they may not be able to prove 100% of the case. Therefore, we may apt to settle a case under a contributory negligence standard that we might not into comparative negligence. Because comparative negligence, we're almost guaranteed of some recovery as long as we weren't 50% responsible. But with the contributory negligence, we might not be guaranteed of any recovery, so we'd be more likely to settle the case. Which is fairer? Impossible question to answer.
Michael Friedman, personal injury attorney, thank you so much.
You're welcome. Thanks, Gary.